Reading the second part of your message, my heart sank. And I'm really sorry. For sure fell short. And you worked really hard on that. And the way you framed it and how that made you feel, I just want to say thank you for sharing that with me. That takes a lot of trust and vulnerability. I feel really grateful that you feel safe enough to tell me that that's how you feel.
Hi, besties. Well, it would appear that Blake Lively cracked under pressure. And in her deposition, she exposed some details about this quote unquote smear campaign that she has been telling the whole world has been going on for months and months and months. And this is the reason why her reputation is in the toilet. And this is why everyone hates her. It's not because of her own doing, but it's because of Wayfarer. And apparently, Blake Lively is abandoning the whole premise that brought her to today. The whole New York Times article of they smeared me before and during the premiere, they retaliated against me. Well, after her attorneys apparently filed this letter to the judge to clarify why they want Brian Friedman's communications with content creators or with literally anyone and why they want Mr. Friedman's bank accounts and telephone records, they had to let the court know that, the reason why we're doing this is because Mr. Friedman is running an ongoing smear campaign, and Mr. Friedman, he's doing these interviews and he's calling her derogatory names and this and that. And it's very important that we have these details because we have to, show you that this is what he's doing, turning him into a fact witness instead of a attorney, which a lot of the attorneys on social media are saying is pretty underhanded and dirty. It's not generally something you would do to your opposing counsel because then they can do it to you. You generally don't try to drag in the opposing counsel into your case and attack them. It's just not good. It's not good practice. It's not showing that you respect the process or the court. It's having to destroy them in order to win. And if that's all she's got right now is to destroy Friedman, she doesn't have anything. So it's like a deflective tool. It's a power move. It's underhanded, in my opinion. But Kevin responded, which exposed some details about her deposition. And I really like that Kevin Fritz is now starting to use more pointed language and he's being more aggressive in how he's phrasing things because I think we're really trying to drive home to the judge that what she's doing is harassing people through subpoenas. They write, to justify the harassing subpoena, the letter erroneously alleges that Brian Friedman Esquire defamed Lively and that his conduct has amounted to public relations work rather than that of an attorney. It appears that Lively is slowly realizing that there is no retaliatory smear campaign by the Wayfarer parties against her. Consequently, Lively is shifting her focus to Liner Friedman in connection with her 14th cause of action, which alleges that certain Wayfarer parties, through their attorney Friedman, purportedly defamed her via post litigation statements to the media. So he's claiming that she doesn't have a lot of evidence for a smear campaign. So instead, she wants to move to defamation by them, shifting where she's going to, try to get the most bang for her buck. And they go into something which is redacted so you can't see it, but it says upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then it's redacted, and it apparently occurred at 2 hours in to this. And then so we don't know exactly what they said there, but we can imply that it has to do with counterclaims because he says counterclaims filed without retaliatory motive with a reasonable basis in fact and law, such as claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. Moreover, statements by the Wayfarer parties to the media directly or through their counsel defending themselves against her bogus claims of harassment do not qualify as retaliatory conduct. So she has no retaliation outside of apparently the fact that they filed a countersuit against her, and that defending themselves in the media is thus proving that they're retaliating against her. Mind you, they would have never said a word had she not brought her own bogus lawsuit to the forefront that they would have to have defended. Thus, she's seemingly abandoning this whole, well, they smeared me with an untraceable digital army, and now it's, well, now they're retaliating because they're defending themselves and they filed a retaliatory lawsuit against me. And they're claiming that this actually doesn't constitute an adverse employment action. And they use rulings by Judge Lyman as proof for that one. And then also statements by the Wayfarer parties to the media do or directly or through counsel defending themselves against Lively's bogus claim of harassment do not qualify as retaliatory conduct. Again, using one of Lyman's own rulings from his lawsuit that he went over with McSweeney versus Cohen. He goes on to note that as for the 14th cause of action for defamation, New York law provides an absolute privilege for communications made by individuals participating in a public function, such as executive, legislation, judicial, or quasi-judicial proceedings. The privilege is accorded statements made at all stages of a judicial proceeding and communications among the parties, witnesses, counsel, and the court, provided that the statements may be considered in some way pertinent to the issues in the proceedings. The privilege applies to all statements made in or out of court, regardless of the motives for which they are made. In short, Lively is aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. So, what they're saying is that the same way that Lively got litigation privilege for what she said about them in the CRD complaint and in the lawsuit here and the statements that they're making to the press here, and that was fundamentally why the case was dismissed, they're saying the same would apply to them. So if she is going to use defamation about statements made within litigation or even outside of it, as long as it pertains to the litigation at hand, it's protected and shielded from any lawsuits. So what they can do are one of two things. They can file a motion to dismiss to her most recent second amended complaint, or they can do a summary judgment and have it dismissed that way. So they have two ways to get rid of that claim of defamation: a motion to dismiss or a motion for a summary judgment, because they're saying we have litigation privilege to do our job the same way she does. In any event, Lively does not adequately address the court's inquiry concerning the undue burden imposed upon Liner Friedman by the subpoena. According to Lively, the subpoena is not unduly burdensome because on December 23rd, 2024, days after she caused her allegations in California civil rights complaint to be widely disseminated by the New York Times, her counsel demanded that Liner Friedman cease and desist from, in essence, publicly responding on behalf of the Wayfarer parties. Therefore, according to Lively, Liner Friedman has known for more than 6 months that she may seek discovery from the law firm. However, at the hearing on the motion, the court astutely asked Lively's counsel why discovery was needed from Liner Friedman via the subpoena in connection with the defamation claim if Lively knows which statements are at issue. Lively had no viable response at the hearing and does not offer one now. Indeed, the second amended complaint not only identifies the specific statements by Friedman that Lively contends were defamatory, but also conveniently provides a link to the publications. In brief, Lively knows to whom the statements at issues were made, where they were published, and when, which renders the subpoena unnecessary and unduly burdensome. Oh my goodness. So they're basically just asking the court to dismiss and quash this subpoena, and she doesn't have anything that's hidden here. Essentially, they were hoping to create a claim, in my opinion, by sending that cease and desist and telling them to stop their retaliation, right? So Lively thought that she could file this CRD and then tell them that they didn't have a right to defend themselves, thus controlling their speech, right? Controlling the speech of Justin, Jamie, and any of the Wayfair parties, making it so that if they even try to talk to the media or a content creator or an independent journalist, they are retaliating against her. Think of it this way. Any good lawyer, when you decide to file a lawsuit, will counsel you and tell you the risks and the benefits of filing the suit. A good attorney will let their client know that filing a lawsuit puts the dispute into a public forum, enabling the opposing side an opportunity to respond, knowing full well that under the law, if you're accused of something, you have a right to defend yourself. Cases are not brought to a court with just a plaintiff's side where the defense gets no say. I mean, that would mean all you would have to do to go to court is accuse someone of anything, and the court goes, "Okay, I believe you. You're right. Judgment, plaintiff." A good attorney will explain to their client, "Are you sure you want to do this?" They're going to be able to bring up all their receipts. They're going to be able to show their side of the story. They're going to be able to demonstrate the facts that they have. They might be able to uncover what you did. They might expose you, right? And you can't stop them from speaking, and you can't stop them from trying to defend themselves. And so now their latest stunt is, okay, we don't have anything for a smear campaign, and we never did. So right off the bat, it was, we're going to try to trump up a charge against Friedman, tell him, if you speak, you are defying this clause in our non-disparagement agreement, and you will be sued, and it will be deemed a retaliatory act. That is not how the law works. Once you file a lawsuit against a defendant, the defendant has a right to defend themselves. They have a right to a jury trial. They have a right to due process. They have a right to understand what the claims are against them. And they also are entitled to the same litigation privilege that you have. So what Lively did was, in my opinion, is she wanted to go out onto the press and smear Wayfair, and she didn't want them to respond. And she thought that if she threatened them with a cease and desist and said, "Listen, you're retaliating and you can't speak," then she'd be able to win in the public opinion, and she wouldn't be able to, lose. Her plot wouldn't have been exposed. You don't get to talk. This is my time. I get to expose you, but you don't get to defend yourself. And by the way, my attorneys can run around to every outlet and they can call you a sexual predator. They can call you Darbo. They can say you're an abuser. They can say that you're using every tactic in the abuser's playbook. They can call your attorney dangerous, say that your attorney punches people, lob false allegations against your attorney, against you, against literally everyone in the media, every content creator that's covered you. Every single person that is not speaking positively about me is a part of the smear campaign. And thus, what she's doing is she's equating their defense and their receipts that they've put out against her as a smear campaign. And that Brian going on to an interview and answering questions about the litigation and the facts of the litigation from the perspective of Wayfair, and then providing his receipts to the media, which counter what she has presented, he's just doing his job. And he had to be aggressive because their company was getting demolished. He lost opportunities. He was dropped by his agent. They lost film projects. They're not making like Pac-Man. I don't think they're even making Pac-Man anymore. Now, and the sequel that could have been another, step for them of more money along with accolades with It Starts With Us, that's scrapped. So they had to fight back because what she was saying was so catastrophic to their reputations. So in Blake's eyes, you can say whatever you want. She can say whatever she wants about you, but you can't respond. And that's just, wow. That's some level of narcissism, if you ask me. And it's really, I mean, I guess, she's getting a taste of what Wayfair went through, right? Wayfair was defamed through this litigation. They were, because New York has an absolute privilege. And that might be why she filed in New York, I don't know. But if she gets litigation privilege, the same right is afforded to them, and she can't tell their attorney that they can't speak. So they tried to get around Wayfair defending themselves by threatening to sue the attorney if they broke the cease and desist. It's so wild if you think about it. So try to completely silence, intimidate, and harass them, and then make them feel like even a response is retaliation. That's serious gaslighting. Uh, I don't know what the judge is gonna decide on the subpoena. I really don't. If Blake knows the statements he made, and if she wants to know that they defamed her, and she wants access to communications, how is she gonna prove that those statements came from Justin and get around attorney-client privilege? She can't. And then in their hearing, she said she didn't want any confidential information or client privilege information. And even if all of this is true, as Kevin Fritz was saying, none of it matters because we have litigation privilege. It's funny when the tactics you employ against your other side come back and bite you in the ass because you thought you got so far ahead of them by going through the legal system, not realizing they would have the same right as you. And mind you, again, she never would have, none of this would have come out had she not trumped up these obnoxious claims against them. And this further drives home the point that this ongoing smear campaign is not a smear campaign. And then it means that the 107 subpoenas she made to content creators were done in bad faith for retaliatory purposes and for intimidation and harassment. Not because she thinks that we've done anything, but to shut us up. I said last week that I wondered if I could write a letter to the judge, but I looked up the rules of the Southern District of New York, and because I didn't file a motion to quash, and because I didn't actually speak directly to Blake's attorneys themselves, it was my attorney speaking to her attorneys. I don't really have the right, I guess, to file anything in the court because as far as the court knows, I'm irrelevant. I suppose I could try to like support a motion for a protective order, but even then, I have counsel, and my counsel would be the ones that do it. And I don't know that I want to spend money with my attorney writing a letter to the judge about a protective order. It just, as much as I want to have my say to her, I don't know if I can because I already have counsel. I'm represented as far as the court is concerned and as far as Lively is concerned because they dealt with my attorneys. So now I suddenly can't go pro se. And I don't know, I don't wanna pay my lawyers $5,000 to write a protective order motion just to make me feel better. So, to the content creators that keep going, good for you, keep sticking it to her, keep fighting. I'm going to just keep shouting it from the rooftop that all of this was done in bad faith, and she cracks under pressure. I mean, if she's in a deposition and she can't even prove a smear campaign, and now that she's going to abandon the smear campaign and now we're gonna focus on defamation, how is defamation retaliation? It's not. It's like she threw a bunch of crap at the wall, and as each one of the claims has fallen apart, she's been forced to move to the next thing. Okay, so we don't have smear campaign in the beginning. Great. Okay, so we're not going to meet the sexual harassment stuff. Okay, so we're not going to meet the smear campaign of the ongoing after. Okay, so now we just need to go to Lyman or Friedman, and it's his fault. Oh my God. What a waste of time and money and resources. I can't wait to see the full transcript. He sealed it, but I really hope that the whole transcript of the depositions becomes part of our like life that we get to read and really sink our teeth into. I would love to see all of the lies that came out of her mouth. Let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.